Good morning, government students. Welcome to Lesson 5, dealing with the judicial branch. Sorry I'm not back in the classroom today, just worked out to be able to do it here. A little bit better situation to work from. Definitely a lot quieter than being at school. But today we're going to continue in our lesson dealing with the judicial branch and the reasons or the purposes behind the judicial branch. And today we're going to deal with some things to get us ready in our discussion. So we're going to determine what the Constitution said as far as what type of cases they are able to handle. The other thing that we're going to look at is different terminology. So this is kind of a technical lesson, not as many stories or illustrations. We're some, I guess, but we're just going to get through this as quickly as we can. These are very important that you will have in your end of the week review, as well as you'll need to know this information for the test in a couple weeks. Okay? All right, so this is week 2, lesson 5. Remember, we're only having 2 lessons this week. There won't be another one. We'll get back to having 3 in next week. All right, so we've already determined that the purpose of the court, and this was decided by those 2 court cases that we looked at before, Marbury versus Madison. Back in 1801, I know some of you had questions whether it was 1801 or 1803, but 1801 is when the court case was filed. All right, and then McCulloch versus Maryland. So the Marbury versus Madison basically gave the idea that the courts could interpret law to determine if they were constitutional or not. And then in the McCulloch versus Maryland, the courts could determine if a law in a state superseded a federal law or the Constitution itself, which is illegal according to Article 6 of the Constitution. So in those 2 court cases, and John Marshall is Chief Justice of the Supreme Court at that time, we determined that the purpose of the court is what we call judicial review. So we've already determined that. Now, we also talked about what jurisdiction, what authority, what's the realm of authority. Well, in Article 3 of the Constitution, dealing with the judicial branch, in Section 2, it basically covers different types of court cases that the Supreme Court will deal with specifically. All the other stuff basically goes to the lower courts or the state courts, but this is specifically stated in the Constitution that the Supreme Court deals with. So the first one is, and it makes sense because it deals with a federal level. It doesn't deal with state law or anything like that. So the federal court system needs to handle these things. So you have an ambassador or other representatives of foreign governments who break laws or we have issues with, then the Supreme Court or the federal courts will deal with that. The second one listed there is maritime law or crimes at sea. I think it was back in 1982 they passed an international code of what those are going to, how far out is international waters, national waters, and things of that nature. So the 2 things that, because their state boundaries don't go out past a certain point along the coast, and so 12 miles out, you start from your coastline. 12 nautical miles, you start international waters. But up to 200 miles out, you have what we call your economic waters. And that deals with your fishing rights, oil deposit, things of that nature. Anything beyond that is considered international, economically speaking. And then anything within the 12 miles, then that's something that so if there's a crime out there or anything, that's a federal crime. It's not a state crime. So if there's a murder on a boat 10 miles out, then that's a federal court case, not a state court case. Okay? So maritime law, crimes at sea, things of that nature. Bankruptcy cases. Now, all the bankruptcy laws did not come about until the latter part of the 1800s. We see some of those things coming into play more specifically, and then you have some other things as time goes on creeping in on how to file bankruptcy, what types of bankruptcy, and things of that nature. So that's a federal case as well. Cases that involve 2 or more states. So you have a state going against a state. Okay, neither one of them can have jurisdiction over the 2 together. They're not going to give up their autonomy in that situation. So then the federal government, just like the Constitution and federal laws, the federal government oversees that. So anything that deals with 2 states. So the rest of the cases that we look at, basically anything that deals with 2 or more states, or people from different states, it's going to be federal. All right. Next one, cases that involve citizens of different states. Okay, again, different states. So you have this citizen, this citizen. You need a non-biased court to be able to handle that. That would be the federal court. Cases that involve a state and a citizen of a different state or country. Cases that involve citizens of the same state claiming lands in a different state. So let's say you have two people living in California and they're claiming land in New Mexico. All right, then again, New Mexico can't take the case because it has autonomy over New Mexico, but the people, California has autonomy over them. So now you need the federal system to come in. All right, U.S. laws, treaties, or interpretation of the Constitution, which we had already seen. And then another thing that's said in there, and I've always thought this was quite interesting, but you cannot bring suit against the federal government unless it agrees. And there are certain things in there that you can bring suit for against the federal government, but then the federal government goes, okay, yeah, we agree with you, file suit, and we'll see what we can do. All right, so the rest of us, if we get sued, we don't have to agree with it, we just get sued, whereas the federal government has to agree with it. It's an interesting point in the Constitution. All right, now we get to terms of the court. So what you can do is you can take a couple of moments, and if you run out of time because we move on, you want to write these things down, okay, so that you know how these things work. So if you look at this chart, okay, and we're going to use the first case that we talked about, Marbury versus Madison. All right, so always the first person in a civil case, and remember, civil is dealing with your citizen rights, okay? In a civil case, the first person is always the plaintiff, and the plaintiff is a person who files suit, okay? So even if you sued the federal government, you would be considered the plaintiff. If you sued the state of Hawaii, you would be considered the plaintiff, the one filing suit. So the one bringing something against someone else is the first person mentioned there. And then the second person is always versus so-and-so or versus Madison here is the defendant, one against whom a legal charge has been made. So if you get sued, you'll be the defendant. If you do the suing, you'd be the plaintiff. And then this is in civil cases. In criminal cases, it changes just a little bit. So in a criminal case, you do not have a person versus a person. It's always a civil authority that brings suit against or brings charge against the accused. Okay? So in a criminal case, it has to be a state or the federal government. So the prosecution, that's what the prosecution, the responsibility to prove guilt. So you need to know these things, that the person who is prosecuting, to bring to trial, to bring charges against, is what prosecute means, to bring charges against. All right, in that sense, the responsibility to prove guilt and the burden of proof lies upon the prosecution. Remember, we have a constitutional principle that basically says that we are innocent. Even if charges are brought against us, we are innocent until proven guilty. All right? And then the person who is being accused is always the defendant. So the person bringing a charge is the prosecution. The person that is being charged is considered the defendant. There we have innocent until proven guilty. And every time an accusation is made or proof of guilt has been brought against you, you have a right to defend yourself against that proof that has been offered or the person who is representing you. All right, so these are the two types, civil cases and criminal cases, and you have plaintiff versus defendant and prosecution versus defendant. Okay, both of them are defendant. All right, now we get to some other terms, okay? And the reason we're going over this because we will be talking about them or using them without defining them. Okay, so when we use these later on in our discussions, then you need to know what these terms mean. A brief is a legal document that represents the argument supporting a client's position. So they write a brief, and that's what is given, okay, in the court. Precedent, and this word is used a lot. A precedent is a court decision that serves to guide a subsequent decision in a related case. But one of the things is, a lot of people say there's nothing new that's going to come out. So you can always find a decision that was made on something years ago. And then you look at multiple cases that are similar, And basically in those multiple cases, you're going to look at the common thread. What was precedent? So you go all the way back to the first type of case that is, and you see a precedent set. And then usually if there was another case that came that was similar to that one, they would go back to that first one, and that precedent would be used. Same in the next and the next until we get to your case. And then that's what precedent is. But there's always a point in time when it was first done, when a precedent was set. Okay? And that's why in U.S. history we talk about George Washington being the precedent setter, because no one had ever served in that type of position before. So he did a lot of the first that people based their decisions on later on. So he had set a precedent. Okay? To affirm, that makes sense. To approve the decision of a lower court, you're just saying, I agree with this. The decision was made here, it was passed on to us, they made the right decision. That's affirm. Or they can do a reverse. Okay, a reverse is to rule against the lower court's decision by virtue of a higher court's authority. So the Supreme Court's the highest court in the land. So if they say that, you can appeal one more time, but there is no court higher that you can appeal to except for God himself. Okay, so they can say, your decision was wrong, you need to change it. All right, now we get into some Latin terms. Okay, and these are the last ones we're going to deal with today, and then we'll get to a few more terms on Monday, and then also the people of the court, all the different positions of the court. So we've already talked about the writs of mandamus, and that is a court order that commands a government official to take a particular action. And remember, in Marbury versus Madison, he wanted the courts to issue a writs of mandamus, which means you need to make him give me those papers. All right, so we've already talked about that one and seen it. Stare decisis is literally let the decision stand. So the practice of basing legal decisions on the established Supreme Court precedents from similar cases. So in other words, the decision in this lower court was this, okay, and it was based on these precedents, then let it stand. It's already been proven this is the way it needs to be handled. There's no extenuating circumstances that's going to make us look at this different. So let it stand. Decisis, okay? And the writs of certiorari, okay, literally made more certain an order from a higher court requiring a lower court to send a record of a case for review. So in other words, it is brought to the attention of a higher court that this decision was wrong or it needs to be looked at. Then what they can do is send a law. A writ is basically an official law or official ruling saying you need to do this. That's what a writ is. And so what they're basically saying here is send this to us because we're going to review it. They're under that authority. They have to send it. All right? So these are the major terms that we've gotten thus far. We'll look at more. We're at our time limit for today. So we'll look at more on Monday, finish up our terms of the court, and then get into the people of the court. All right. The Lord bless you. I hope you have an incredible weekend, this Easter weekend, and hope you get to spend some special time with the Lord this weekend and thanking Him for His sacrifice on the cross. All right. God bless, and we'll see you next week.